thank you for joining us for today's webinar. My name is Michaela Vrazdova, and I'm a senior attorney at Scott Legal. Today, we are going to spend some time talking about the employment-based green cards. And I wanted to mention a few things before we get started. So Scott Legal is a full-service immigration law firm, and we assist individuals and companies pursuing various types of visas and green cards. We can assist with family-based visas and green cards and employment-based visas and green cards. And our main specialty is assisting entrepreneurs and investors. And we regularly process a high number of various employment-based green card petitions. We will continue to have this webinar series, and we will have at least 2 webinars a month on different visa topics. At the end of this webinar, we'll send you out a few things. We will send you this PowerPoint we'll be using during today's webinar. We will send you our comprehensive visa guide, and we will also send you a link where you can sign up for additional webinars we will have in the future. And we will also send you a link for today's webinar as it's being recorded. This webinar will be available on our YouTube channel, and we encourage you to subscribe and hit the notification button as we regularly post immigration videos on our YouTube channel. And we will also send you a link where you can set up a consultation with one of our attorneys. Today, we are lucky to have Kelly LeGrand Weiner, who is a managing attorney at the firm, and she has a vast experience processing different types of employment-based green cards. And as I mentioned, my name is Michaela Vrazdova, and I'm a senior attorney at the firm. And finally, for any questions you have, please add them in the Q&A section or in the chat box, and we will get to all questions at the end of the presentation. Perfect. So why don't we get started and do a brief overview of all the green card, employment-based green card categories. So the first employment-based green card category is called EB-1A green card. And this green card is reserved for individuals who have extraordinary ability in the field of science, arts, education, business, or athletics. And this green card is reserved for kind of very small percentage of people who have arisen to the very top of their field. And to kind of apply for this green card, you can either find a US company that will sponsor you, or a huge advantage of this green card is that you can also file a self-petition, meaning that you don't need a US sponsor and you can just self-petition yourself. The second type of employment-based green card is called EB-1B, green card for outstanding researchers or professors. And to qualify for this green card, you must show that you have international recognition for your outstanding achievements in a particular academic field. And you must be coming to the US to kind of pursue a tenure or kind of like a comparable research position at a US university or for a private employer. Third type of kind of employment-based green card is called EB-1C for multinational managers or executives. And this is kind of a green card equivalent to the L1 visa, but they kind of do have some different requirements, but it is similar to the L1 non-immigrant visa. So for the EB-1C, you must show that you have been employed outside the US for at least 1 year in the most recent 3 years before filing the petition, or if you are already working for the US company, you must show that you have been employed by the foreign company for at least 1 year before you entered the US on the non-immigrant visa. Both the foreign company and the US company must be kind of operating and doing business, and there must be a qualifying relationship between the two companies. The next category of green card is called EB2 green card. And there are two kind of like subcategories of this green card. So one is called a National Interest Waiver. And a huge kind of advantage of this category is that you can self-petition. So again, you don't necessarily need a US company that will sponsor you. And another big advantage is that you don't need to go through, or the company doesn't need to go through the labor certification process that we'll kind of discuss later during the presentation. And we do have a specific webinar on the NIW. So if you are interested to hear more about this category, we recommend to sign up for that webinar. And the second category of the EB2 green card is called, is kind of like a green card through the PERM process. So for this subcategory, you will need a US company that will sponsor you for the green card. And to kind of qualify under this category, the job in the US must require an advanced degree, which means master's or a bachelor's year plus 5 years of progressive work experience. And the degree can be either a degree from US university or foreign equivalent. Then we also have a EB3 green card, and this is for professionals, skilled and unskilled workers. And for this category, you will need a US company that will sponsor you. So there is unfortunately no option to kind of self-petition here. And so there are three subcategories here. So skilled workers, you know, for this subcategory, you would have to show that the employer would have to show that the job requires a minimum of 2 years of training or experience. For the professionals, the job has to require a bachelor's degree or foreign equivalent. And for the unskilled worker category, the job, you know, the job, this category is for a person kind of performing unskilled labor and would require less than 2 years of training or experience. Then the next category is EB4 green card, and this is for so-called special immigrants. There are kind of like many subcategories. One of them is, for example, you know, for religious workers. And the last category of employment-based green card is EB5 green card, and this is an investment-based green card. So to qualify for the EB5, you would have to invest either $800,000 or $1,050,000, depending which area of the US you are investing the money in. You would have to show that the money is coming from legitimate source, and the business would have to create 10 full-time jobs. Perfect. So now Kelly will take over, and she will go over the labor certification process.
Thank you, Michaela. Perfect. So the main purpose of the webinar today is to talk a bit more in detail about the EB2 and EB3 categories, specifically in the labor certification process. So what is the labor certification process, also called PERM? So this is the process where a U.S. company sponsors an applicant for a green card for full-time employment in the U.S. There are basically 3 steps to this process. You know, the actual PERM itself, which is, I'd say, probably the longest part of the process and the most complex. And then there's the filing of the I-140 petition, which is the company's petition, you know, for an immigrant worker. And then there's the filing of the I-485, or filing for the green card at a consulate, which is, you know, when you're actually getting your green card. That's the individual petition that the employee files. So let's talk a little bit about the PERM. So for the PERM, you have to, the company has to go through multiple steps to be able to sponsor a foreign employee for a green card. So, you know, one of those steps is they need to get a prevailing wage determination from the Department of Labor. And this prevailing wage determination tells you, you know, how much you have to pay the worker once they get the green card in the future. So the company has to be willing to pay at least that amount, if not more, once the actual worker, gets the green card in the future. And the prevailing wage is based on, kind of several things, the job description, the job requirements, the location of the job, wages in that area for that particular type of job. So another, key part of the PERM is drafting what we call kind of a PERM compliant job description. So normally, in some type, when you're advertising for a job, employers will put in lots of things like, their ideal requirements. So, bachelor's degree required, but master's preferred, or, great communicator, team player. So for the PERM process, the employer is required to determine what are the minimum requirements to do the job in a reasonable manner. So the job description often has to be altered, usually working with the attorney to ensure that it meets that requirement that the PERM puts forth. So once this job description is in place and the prevailing wage has been issued by the Department of Labor, that's when you have to go through the recruitment process. And so this is where the company actually has to test the US labor market. So they have to put the job description out, place multiple ads. If it's for a non-professional position, then you just need to do 3 ads, so with the state workforce agency, then 2 consecutive, Sunday newspaper ads, and then a notice of filing where at the job work site. If it's for a professional position, you also have to do 3 additional forms of advertisement, and there's 10 different forms of advertisement you can choose from. And so it has to be kind of done under this regulatory framework. So once they test the labor market, they actually have to review resumes. If anyone appears minimally qualified, they need to be interviewed. If no willing, qualified, or available US workers are found for the position, that's when the company can go ahead and prepare the actual labor certification at the end of the process. So the recruitment process includes 30 days where the ads are active, and then there's a 30-day quiet period where the ads may not be active anymore, but the company still has to review resumes, interview anyone who appears qualified, and determine if they can proceed to the next step in the process. So once the labor certification is prepared, in conjunction with that, the company needs to prepare what we call an audit file. So this is the proof that the company actually, placed the advertisements they say it placed, that they actually interviewed people. They need to keep records of all the resumes. If there's any requirements that are over and above what's normal for a particular position, they need to include documents supporting the business necessity for those requirements. So all of that is prepared, between the employer and the attorney before the labor certification is filed with the Department of Labor. Important to talk about some audit triggers. So once you file the labor certification, it can either be denied, certified, or it can be audited. If it is audited, then you have 30 days to prepare a response, and that audit file that you prepared before filing often will make up the bulk of what you're submitting to the Department of Labor. There are some particular audit triggers. So for example, if the job requires that you speak a foreign language, there's a very high standard for when jobs are allowed to require this. Additionally, if the requirements are outside what's normally, required for the occupation, this can also be an audit trigger. There also tend to be kind of trends in audits. So, in various years, we see kind of different types of cases being targeted. So there was a period of time where kind of many unskilled worker, PERMs were being audited. So, so that is something to keep in mind as well, and that you want to discuss with your attorney when you're preparing the application. Because if you are audited, once you submit your response, it can add several months to the process because it can take quite a while for them to respond to your audit. So, once at each stage of this process, let's talk about timing a little bit. At each stage of the process has its own timing, and that timing changes. So for right now, prevailing wages, some of them are taking over a year to be, to be issued. So that can really impact the timing of the process. The recruitment process by regulation has to be at least 60 days before you can file. And then once the cases are filed, the labor certification process, that's also taking several months, sometimes upwards of 8 months right now. And if you're audited, several months over and above that. So you do want to make sure you're building in enough time as the employer and the employee, especially if you're in the US on a visa that will run out. You want to kind of just consider that in terms of the PERM timing. Once you get to the stage, if the PERM has been certified, now you can move on to step 2. That's filing the I-140 petition. This is, the benefit of this is you can pay for premium processing. So you can pay $2,500 to get an answer within 15 calendar days. And for the I-140, what you're doing is the company is submitting proof of their ability to pay the prevailing wage. So the company has to prove that they had the ability to pay the prevailing wage at the time the PERM was filed, and that they will continue to have that. So either, tax returns, audited financials, or if the company is very large, sometimes they can submit a statement from the CFO. And then also with the I-140, you have to prove that the employee applicant meets all of the requirements in the labor certification. So if the labor certification said this job requires, a bachelor's degree in business and 2 years of experience in recruitment, you need to be able to demonstrate that the employee applicant had the bachelor's degree and the 2 years of experience in recruitment prior to joining the company, if they currently work for the company. So this is shown through, the degree, the transcripts, a credentials evaluation, if it's a foreign degree, and also employer verification letters that have the details from prior employers as to what this person's experience was. Once you get to that, once the I-140 is approved, if there's an immigrant visa available in your category, then you can file the I-485 if you're in the United States in a valid status, or you can file through consular processing. And we'll talk a little bit more about that later. The I-485, when we talk about, a category being current or not, this is based on the visa bulletin. There's only a certain number of immigrant visas that can be issued each year in each individual category, and, to individuals of certain countries. So there's some countries like India and China where there's very, backlogs are happening. And there's some countries, even in the general EB2 category right now is backlogged. So always important to consider that, in your timing, as you may not be able to file the I-485 concurrently with the I-140, or even after the I-140 was approved, if your category is not current yet. In terms of family members, you can, once you're at this stage of filing the green card application, let's say your family members are here in the US with you, you're on an H-1B and they're on H-4 visas. If your category is current, then you can go ahead and you can all file your, I-485 applications together. For your children, they need to be under 21 and unmarried in order to be part of your application. So let's talk a little bit about kind of the adjustment of status versus consular processing. So the, adjustment of status, the process is you will file the I-485 with USCIS within the United States. The benefits you get are you have the ability to remain in the US while the I-485 is pending. When the I-485 is filed, you also can file for work and travel authorization. Those applications are taking several months to be approved, but once they are approved, they allow you to, to work and travel outside the United States. At the end of the process, most applicants will have an interview with the USCIS officer. There's times that those interviews are waived, but it's become less likely over the past few years. So generally, if for adjustment of status, people are going to choose this option if they are already living and working in the United States, and that's where their home base is, and they want to stay there, and they don't have any issue kind of staying for several months while they wait for the travel authorization to come through. There is a caveat for people that are on H and L status. They may be able to travel without, waiting for that travel authorization. That's kind of a special benefit you get on H-1B and L-1 status. But it's always important to discuss, with your attorney before departing the United States to make sure you're not impacting or abandoning the I-485 application by traveling. The other option here is consular processing. So in the entire PERM process, for most applicants, I would say they're already working for the US employer. However, that's not always the case. And the PERM is a prospective application where you're looking to the future. This is a job you're going to hold in the future when you have your green card. So for some people, perhaps they're not in the US anymore and an employer is sponsoring them, or perhaps for whatever reason, the I-485 process just isn't the best process for them. Perhaps they need to travel constantly and they're not on an H-1B or an L. They can't stay in the United States and just wait, for the travel authorization. So under the consular processing green card process, the way that it works is once your I-140 is approved, that approval is sent to the National Visa Center. The National Visa Center will then reach out to you and your attorney with instructions to pay an initial fee and how to submit the DS-260 application. You then submit your DS-260 and all of your supporting biographical documents to the National Visa Center. They will then review and let you know once your case is documentarily complete. It will then be sent to the U.S. consulate where you last resided, and the consulate will then be responsible for booking an appointment for you. You will attend an interview at the consulate. If your green card application is approved, they'll collect your passport. They'll put an immigrant visa into your passport, and then you will be able to enter the United States while that immigrant visa is valid. It's usually valid for 6 months. And then once you're in the United States and you've paid your immigrant visa fee, then your green card will be mailed to you, usually within a couple of months. So, there's both are kind of viable processes. It really depends, on the applicant's, particular circumstances. But if the person is living and working in the United States, very often they will opt for adjustment of status. So let's also talk about who can pay for green card fees. So this is a very common question. I think it's relatively clear that the PERM process and the legal process fees need to be paid by the sponsoring employer. And there cannot be kind of an agreement between the employer and employee that the employer will pay and the employee will just reimburse them later. It's just very specific that, when it comes to the PERM, the employee cannot pay for those, for those fees. When you come to the I-140 part of the application or the I-485 or any fees that are paid for your dependents, those can be paid by the employer or the employee. So there's a bit more flexibility there. So let's talk a little bit about dual intent. So dual intent is the concept that you can be in the US on a temporary visa like an H-1B, but it's still permitted that you apply for a permanent visa like a green card. So there are kind of, single intent visas like the TN or the F1. Those are visas where they have a very high standard. You need to show there's a residence abroad you don't intend to abandon. But for the, dual intent visas, you don't have that issue. I'd say the dual intent visas where it's very well established their dual intent are the H-1B and the L. The O is kind of more of a quasi dual intent visa. Over the years, there's been kind of regulatory language added to the Foreign Affairs Manual that has indicated, and kind of state policy statements from USCIS that have kind of indicated that there is like an understanding that, people on O status, can still renew their visas, even if they have, an I-130 or an I-140 petition pending. That being said, the H-1B and the L are the ones that are really the dual intent visas. The benefit of being on a dual intent visa while you're going through the green card process is there's just less concern about kind of travel in and out of the United States and also about renewing your visa. So let's say you're on a TN visa and your employer is going through the green card process for you. Once your I-140 is filed, it's going to be much more difficult to renew the TN because the TN does require that you have that intent not to abandon your foreign residence. And once you have an I-140 filed, it's a bit harder to argue that you don't have immigrant intent. So for that reason, some people, will choose to try to move to a dual intent visa, before or during the green card process so that they're not encountering those issues at the border and they have that ability to stay in the US. That being said, if you're on a TN visa and you're already in the United States and your employer is going through the green card process for you, that is permitted. There's nothing that kind of is wrong with that, but just at a certain point in the process, traveling and renewing the visa is going to become much more difficult. All right, let's talk about considerations when moving from a non-immigrant visa to a permanent green card. So, always consider timing and your underlying status. How much time is left on your visa? So as we just discussed, some visas are harder to extend, once an I-140 petition is filed or your I-485 petition is filed. Sometimes at that point, you can't really extend your visa. You can't depart the United States and, can't extend from within the United States because you have a green card petition pending. So your immigrant intent is established. Also good things to consider, the H-1B, you max out at 6 years. However, if you're at a certain stage of the green card process or you have an I-140 approved and an immigrant visa is not available to you, you can possibly get extensions beyond the 6 years. So you always want to be thinking about that with, and talking with your attorney and making sure that the timelines are aligning so that if, the goal is to stay in the United States and have unbroken work authorization, that you are planning for that. To make sure that you do have, the ability to keep extending your status beyond, the timeframes. For example, if you're on L status, L1A will max out at 7 years, L1B will max out at 5 years, and there is not an ability like there is with the H1B to, extend beyond those timelines. So if you have an I-485 pending and you have work authorization based on that pending I-485, you can work, but not having that underlying status, some people prefer to have that. It can be beneficial to have that underlying status. So when you're considering, this process, you also just want to make sure, do you want to adjust in the US or do you want to go through consular processing? So make those considerations. When you're filing your I-140 petition, you have to indicate which you plan to do. And generally, if you don't know, it's best to indicate you're going to consular process because it can be very complicated to get your immigrant visa approval transferred to the National Visa Center if you indicate you're going to adjust status and later you decide you want a consular process. So just things to consider. Also, obviously, also consider your family members. Do you have children where you want them to have the green card? In that case, perhaps, you want to talk with your employer earlier on. You want to start your planning early to avoid any issues with your children aging out, which they will do once they're, 21 or married. All right, so let's talk about the green card interview. Before you go to your green card interview, it's a good idea to, you want to review your immigrant visa petition, so your I-140 petition, and also your I-485 green card petition, or if you're going to the consulate, your DS-260 application and your supporting documents. Organize and print all the documents to bring with you to the interview. You'll need to bring original documents of certain things like birth and marriage certificates, but you should also bring copies of those. The consulate or USCIS should have those. They should already have those documents, copies of them. However, they always ask you to bring copies just in case they want to look at them, and they want, it's a good idea to have the originals as well. Usually there'll be, an interview notice that contains very explicit instructions about what they want to see, and you want to make sure you have all those documents with you. Always better to have it and not need it than to need it and not have it. For your medical exam, if you're going with USCIS, it will be done on form I-693. It should be a sealed envelope that either, you provided previously or you're providing at the interview. You want to make sure that it's not expired. They do expire after 2 years. You want to get updated proof of employment from your sponsoring employer. So, a letter that confirms, what job you're being offered, what the salary is, what the job duties are, and ensure that it aligns with everything that was in your labor certification. If you're here and you're already working, you want to get that proof of maintenance of status, if you're adjusting status in the US. So, your pay stubs, your visas, all those underlying documents showing that you're here in legal status. Meet with your attorney and do a practice interview. It's a good idea to, it's likely you'll be nervous. It's a good idea to just kind of run through some basic questions with your attorney just to kind of practice. When we talk about kind of what kind of questions do they ask at the interview, often they'll ask for kind of the job offer letter. They may ask for your pay stubs, to see if that aligns with what's in the job offer letter. If you aren't currently working for the company for any reason, they may ask, how you're supporting yourself or for documents showing you're maintaining your status in the US. They may ask for details about your company. They're doing kind of a credibility check here. They're not re-adjudicating the I-140, but you should be able to answer basic questions about the company that you work for. that are aligned with, the job that you hold for the company. And then they'll also ask questions about your actual green card application, your I-485. So, the biographical information you put, if you had any immigration violations in your past, they may ask about those. If they had any arrests, anything that would potentially impact your admissibility into the United States, they will ask about those things, and so that could come up as well. If you're applying with a spouse, it may be a good idea to bring, some proof of the validity of your marriage. Generally, they just need to see the marriage certificate, the birth certificates. However, we have had the experience where they ask for more proof of the bona fide relationship. So bringing perhaps, your mortgage statement or joint bank accounts, may also be, a good thing to have just in the event they ask for that. So let's talk about porting. A very common question is, can you change employers during the process? So in a lot of cases, if you're like, let's say your company has just started a PERM for you, and now you want to move to a new employer and you're on an H-1B, there's really nothing, at that point, there's really nothing to preserve, if the PERM has not even been filed, the I-140 hasn't been filed. However, at a very late stage of the green card process, there is this ability to do something called porting. So porting allows employees to change employers after your I-485 application has been pending for at least 180 days. The I-140 connected to that I-485 also has to be approved. If you're in that situation, you have an approved I-140, your I-485 has been pending for at least 180 days, then you can port to a new employer in the same or a similar occupational classification as the job that was offered to you in the I-140. So in that particular circumstance, when you go to the new employer does not have to complete a new PERM or a new I-140. I'd say at many stages of the process, even let's say you have an approved I-140 and you want to move to a new employer, that new employer is going to essentially have to do the entire PERM process over. They're going to have to file their own I-140. The only really benefit that you get is from having that approved I-140 is you can potentially use it for H-1B extensions, depending on your your circumstance, and you can keep that priority date, which can be very helpful if you're in a backlogged category. But however, if you're in the circumstance where, you're 180 days into your I-485, pending, then you do have more flexibility. To establish that your new position is in the same or a similar occupational classification as the previous offer of employment, you're going to submit, documents, for example, the Department of Labor classification codes, description of the job duties, the skills, the experience, the training, any licenses or certifications you need, a comparison of the wages offered for the job, and any other credible, relevant evidence that shows that the job that you're porting to is in the same or a similar occupational classification as the job you were previously approved for. This can also work, porting can also be relevant even within the same company, right? So if the job that you've been working, that you were approved for on the PERM for your company has changed a bit, but is still arguably in a similar occupational classification, you can also make that argument even within the same employer. So that's just something to keep in mind. If you do decide to port, your new employer or the same employer for a new job is going to file Form I-485 Supplement J, and that's going to be adjudicated with your green card application. So another common question is about changing employers after you get your green card. Do I have to stay at this employer forever? What if I get fired? How does this come up? So when you obtain an employment-based green card, both you and the company are essentially making a good faith attestation that the company is saying, they intend to employ you in this full-time role. You're saying you intend to be employed in this full-time role. So it's not a good idea to get your green card and then quit the next day. The place that, technically, are you permitted to do that? Yes, you could get your green card and then you could quit within a short time frame. However, that can come up at the naturalization stage. So if you decide you want to become a US citizen, it's something where the officer could look at your work history. They could ask about, the underlying circumstances under which you got your green card. And if they suspect there was any kind of fraud or misrepresentation, that could potentially endanger your ability to stay in the United States. So, I'd say there is no kind of bright line test of, how long do I need to stay with an employer? But, just something to keep in mind that I think, several months is, you want to, when you're going to your green card interview or getting your green card, you're making that attestation that you plan to work there. So you want to continue, I think, working there for a reasonable period of time. If something happens, for example, you're fired, perhaps your spouse is transferred to another state, there may be things that are explainable, but so you are permitted to change employers after you have your green card, but doing so very, very quickly is something that could lead to questions at the naturalization stage. All right, so I think we are reached the end of the content of the presentation and can turn to some questions.
Yeah. So we have a couple of questions. So the first question is, if you are potentially being sponsored by your current US employer, who or what determines what category you will file, EB2 or EB3? I'm a professional with 4+ years of experience and master's degree in my area. So Kelly, could there be like any advantage to filing under like EB3, or would it usually be filed under the EB2?
Yeah, so it depends on two things. So one is what the job requires, right? So even if you have a master's, if the job only requires a bachelor's degree, it would be filed under EB3. But generally, if you have a master's, the job is going to require a master's. Usually you'll file under EB2. So however, like there are times like right now where the EB2 category is backlogged. So there was, I think for quite a while, people really wanted to file under the EB2 category because there was a feeling that the EB3 category was more retrogressed, more backlogged. However, it kind of has gone back and forth. So, if you have a master's degree, a U.S. master's degree or equivalent to U.S. master's degree, and the job requires a master's degree, you can generally file under EB2, but it's always good to kind of discuss with your, employer and attorney, because sometimes there may be a benefit to filing under EB3 if that category is current or has more favorable dates.
Perfect. Thank you. The next question is, what happens if my current H-1B visa runs out while either the I-140 or I-485 is being processed? Can I still stay in the US and work for my company? So yeah, Kelly, you mentioned that at certain point, the H-1B kind of employee can extend beyond the 6 years. So what point in the application process is that?
Right. So there's kind of two different exceptions that allow you to go beyond the 6 years. So one is if the labor certification or I-140 has been filed 365 days ago. Then you can potentially get another year on your H-1B, or if your I-140 has been approved, but you can't file your green card application because your category is backlogged. At that point, you can get up to a 3-year extension on your H-1B. Let's say that your H-1B just, runs out. You can, as long as you have a valid employment authorization document, you can also continue to work for your company based on that. But while the process is ongoing, you would either need to have gotten that H-1B extension based on the length of time the PERM, was pending, or the lack of availability of a green card, or work based on the employment authorization document. If neither of those were available for some reason, and your employment authorization document hadn't come through, there might be a period of time where you kind of would not be able to work while you were waiting for one of those things to come through.
Perfect, thank you. The next question is, is filing the adjustment of status in the US or consular processing faster? Can you do consular processing if you are already in the US on an H-1B? So yeah, I think this is kind of like, it will depend on like which consulate you are filing, which if you're in the US, like which field office. But maybe Kelly, like what has been your recent experience in particular like consulates or field offices for the processing time?
Yeah, I mean, I think that both are very long. I think that there's both are just very, very long. I think the consulates generally are still quite backlogged. Many of them are. I think that if you're living in the United States and working in the United States, generally the adjustment of status is going to be more favorable. Just because while it may take a similar amount of time to consular processing, it gives you that ability to kind of work and travel in the United States. And yes, you can do consular processing if you're on an H-1B in the US. The fact that you're in the US doesn't mean you have to file an adjustment of status. It's just, something that may be beneficial, if that's where you're living.
Thank you. The next question is, if I'm on an H-1B, can I travel abroad while doing the I-140 and I-485?
So yes, the H-1B is a dual intent visa, and it also has a particular benefit where if you're working for the, if you're working for the same employer and you're coming back into the United States to work for that same employer in the same job, then you can travel on your H-1B even after your I-485 is filed. And that's an exception because most of the time for most people, if they travel after the I-485 is filed and before they have travel authorization, their case will be abandoned. But H-1B has a special benefit there.
Perfect, thank you. The next question is, so someone filed an NIW and it was denied. How long should the person wait or, probably the US company to file the PERM?
So I think that this one's kind of hard to answer without more context. I would suggest kind of I think that some people might have national interest waivers and PERMs ongoing at the same time. Like there's nothing that says that you have to wait any particular period of time. But, there could be many factors, impacting this, someone's underlying status, all of those things. So I'd suggest setting up a consultation to, talk about that question in more context.
Perfect, thank you. The next question is, in which case would the extension to keep working not be granted if you run out of H-1B, but still waiting for the I-485? So I think we already answered this one.
Yeah, right. I mean, basically, you need to either have a valid H-1B based on the, the lengthy adjudication delay exception, or you would need to have a valid employment authorization document.
Perfect. The next question is, I'm a professional with master's degree and a decade of experience in aerospace industry from India. Which visa is best to file? So this is, we would recommend probably to schedule a consultation and to kind of like discuss your, your situation, your qualifications, and then we can best advise, what would be the best visa or green card to file for. The next question is, how does the current date for I-485 work and timing for that? I don't understand. How does the timing for processing that work?
Sure. So when we say that something is current, what we mean is the government has enough visas available to process the green card application at that time. When something's not current, it means that you right now there's a backlog in your category, and the visa cannot be granted until the category becomes current again. So it is quite complicated. I'd say there's some free resources on our website about the visa bulletin and how it works. So, it is something where, for example, a category can be current and your I-485 is pending, and then something happens where it retrogresses. So, they run out essentially of visas, and the category becomes backlogged, and then you would not get your green card until the, visa category was current again. So the timeline for an I-485 pending, that's really dependent on the USCIS field offices that are service centers that are looking at the application. But the question of whether or not there's enough visas available of the to grant you a green card in that particular month, that's a separate issue. I think that's something that I'd say look at the resources on our website. But ultimately, what it just means is that there's only a certain number of green cards that can be granted in any particular year. And if the if the category is not current, it means it's oversubscribed at that particular time.
Perfect, thank you. And then we have a last question. So can a U.S. employer make the employee sign a contract in which the employer would make them pay for the attorney fees by making the employee give up bonuses or salary raises in the next couple of years to balance out the money they spend for the green card application?
Right. So no, generally no, these types of arrangements are not permitted.
Perfect. Yeah, so these are all the questions we had. And thank you everyone for joining us today. And thank you, Kelly, for great presentation.
Thank you.
Thank you. Bye.